Across the United States, a significant shift in immigration policy is quietly unfolding, and it is impacting families in ways few anticipated. The I-130 petition, historically a lifeline for U.S. citizens and green card holders seeking to bring their loved ones into the country, is now under unprecedented scrutiny. Across service centers and consulates, petitioners are experiencing delays, new document requests, and higher standards for financial and relationship verification. For millions who rely on family reunification, this is more than paperwork. It is a struggle to keep families together amid changing rules. In recent months, immigration attorneys and advocacy groups have reported an uptick in requests for additional evidence from USCIS. These requests are not minor. They often involve multiple years of tax returns, proof of ongoing employment, documentation of assets, and detailed verification of family relationships. Couples who have been married for decades, parents trying to bring their children, and adult children seeking to sponsor elderly parents are all facing longer processing times. What was once a process completed in 12 to 14 months is now stretching well beyond 18 months, with some cases lingering even longer, creating real emotional and financial strain for families. At the heart of these changes is a focus on financial ability. The Affidavit of Support, or I-864 form, has become a central point of review. Sponsors with incomes that just meet the federal poverty threshold are seeing their applications delayed, while USCIS requests extensive proof that they can support their relatives without relying on public benefits. Even joint sponsors, who historically made the process easier, are now being required to submit additional documentation and justify their capacity to provide support. This scrutiny disproportionately affects middle and lower income households, making the family reunification process more daunting than ever before. But financial review is only part of the story. USCIS is also examining the legitimacy and ongoing nature of family relationships. Evidence that was previously optional, such as photos, communication logs, proof of in-person visits, and documentation of shared property or finances, is now often mandatory. Officers are directed to confirm not just that a relationship exists, but that it is actively maintained. Couples separated by distance, parents whose children live abroad, and siblings seeking reunification are all navigating increasingly complex and time-consuming documentation requirements. For many, each additional request for evidence adds months to an already lengthy process, leaving families separated for longer periods. The new approach represents a shift from what some advocates call policy by delay. Rather than changing immigration law through Congress, internal guidelines and administrative directives are effectively tightening requirements and slowing approvals. Because these policies are implemented internally, they often take effect quietly and without public debate, leaving petitioners unaware of changes until their cases are delayed or questioned. Backlogs at service centers and the National Visa Center are growing, causing ripple effects that extend to U.S. consulates around the world. Countries with large volumes of immigrant petitions, such as India, Mexico, and the Philippines, are seeing interview appointments delayed by months, further complicating the reunification process. Inside USCIS, officers are under increasing pressure to ensure every case is reviewed with precision. Audit reviews have intensified, and officers are evaluated on adjudicatory accuracy, meaning every file must be carefully checked before approval. While this emphasis on quality might sound positive in theory, in practice it results in slower processing, fewer approvals, and a growing backlog of petitions. Even well-documented, legitimate cases are being delayed, leaving families in a state of uncertainty. Advocates warn that this trend could significantly reduce the number of family-based immigration approvals, particularly for petitioners with modest incomes or unconventional documentation. The human impact of these changes cannot be overstated. A mother in the United States may wait months longer to reunite with her teenage son abroad. A husband may remain separated from his wife for an additional year or more. Elderly parents hoping to join their adult children in the U.S. face prolonged uncertainty, which can affect health, financial stability, and emotional well-being. The consequences of these delays are felt deeply, not just as administrative obstacles, but as real disruptions to family life. Many families fear that financial or documentation requirements may eventually lead to outright denials, compounding the challenges of reunification. For families navigating this evolving system, preparation has never been more important. Submitting a complete petition from the outset, with detailed documentation and organized evidence, is essential. Financial proof should go beyond the minimum, demonstrating stability through bank statements, employment letters, and assets. Relationship evidence should be thorough, including photos, communication logs, and proof of visits. Staying informed about policy changes is also critical. USCIS internal guidelines can shift without public announcement, so monitoring updates through trusted immigration attorneys and reputable sources is key to staying ahead of delays or additional requests for evidence. Looking at the broader picture, these administrative shifts reflect more than procedural changes. They indicate a philosophical change in U.S. immigration priorities. Family reunification, once a central component of the system, appears to be losing emphasis to employment-driven and merit-based immigration. The focus on self-sufficiency, productivity, and economic value is shaping policy implementation, shifting the balance away from compassion and connection toward measurable contributions to the economy. While the rules themselves may not have changed legislatively, the application of those rules is increasingly favoring petitioners who demonstrate financial strength and economic utility, rather than those seeking to unite with family members. The long-term implications of this trend could be significant. Family-based immigration may decline, particularly among middle and lower-income households, resulting in smaller immigrant communities and less cultural cohesion. Children separated from parents, spouses living apart, and elderly parents unable to join adult children could become more common. Communities that have historically relied on family reunification as a means of building support networks may face unique social and economic challenges. Advocates emphasize that family unity has long been a cornerstone of American immigration, and changes that reduce approvals or extend processing times could have lasting societal impacts. In the meantime, families must adapt. Being proactive, meticulous, and thorough in documentation is now more critical than ever. Legal counsel can play a vital role in guiding petitioners through complex evidence requirements and anticipating potential delays. Monitoring USCIS updates, understanding internal review priorities, and submitting detailed and organized applications can help mitigate the effects of slower processing times. While delays may still occur, preparation and awareness can reduce uncertainty and help families maintain hope of reunification. The situation also underscores a larger conversation about the purpose of immigration policy. For decades, the United States has balanced family unity with economic and national interests. Today, that balance appears to be shifting decisively. Internal administrative changes, although technical in nature, are increasingly shaping who can enter the country and under what circumstances. Petitioners without extensive financial documentation or conventional relationship evidence may find themselves disadvantaged, while those demonstrating economic self-sufficiency are more likely to succeed. The message is clear: immigration policy is being reframed around productivity and self-reliance rather than personal or familial need. As we move further into 2025 and look toward the coming years, families seeking reunification face uncertainty. The rules may continue to evolve, delays could lengthen, and approval rates may fluctuate based on administrative priorities. What was once considered a straightforward process may now require careful planning, documentation, and persistence. Families must prepare for longer waits, more requests for evidence, and higher standards for both financial and relational verification. The stakes are personal, and the impact is profound. At the same time, this situation highlights the critical role of advocacy organizations, legal counsel, and informed communities. They provide guidance, resources, and strategies for navigating a complex and increasingly stringent immigration landscape. Their work ensures that families are aware of changes, understand requirements, and can take steps to protect their applications. For those hoping to bring loved ones to the United States, remaining vigilant, organized, and proactive is essential in navigating these evolving policies. Ultimately, the I-130 process, once a reliable pathway to reunification, is undergoing a transformation that emphasizes internal scrutiny, economic self-sufficiency, and detailed verification. The consequences for families are tangible, emotional, and long-lasting. As petitioners navigate delays, requests for additional evidence, and shifting standards, the broader narrative of U.S. immigration is being rewritten, one case at a time. For millions, the challenge is not simply meeting the minimum legal requirements, but understanding how internal policies are reshaping the reality of family-based immigration in the United States. The question for the future is whether these trends will stabilize, expand, or evolve further. For now, petitioners must act with diligence, patience, and awareness. USCIS internal policy changes, while administrative in nature, are reshaping the lives of families across the globe, and the impact is profound. Those seeking to reunite with loved ones must be ready, informed, and prepared to navigate a system that is becoming increasingly complex and exacting. The stakes are high, and the outcome will affect not only individual families, but the broader social and cultural fabric of immigrant communities in the United States. For families, advocates, and observers alike, this is a pivotal moment in U.S. immigration policy. The rules are changing, the process is becoming more demanding, and the personal impact is significant. Understanding, preparing, and acting strategically is essential for anyone navigating the I-130 petition process. The story of family immigration in 2025 is one of challenge, adaptation, and resilience, and it will continue to unfold in the months and years ahead. The hope of reunification remains, but achieving it now requires careful planning, meticulous documentation, and a clear understanding of the shifting administrative landscape.